video, we will discuss how to set up a land trust, its benefits, and how it can protect your assets. What is a land trust? A land trust is a legal entity that allows you to manage and control real estate assets while keeping your ownership private. This can be particularly useful for safeguarding your assets from creditors, lawsuits, and other potential risks. With a land trust, you create a private agreement where a trustee holds the title to a property for the benefit of one or more beneficiaries. The main advantage of a land trust is that it allows the beneficiaries to retain control over the property while keeping their identities confidential. Key features of a land trust include privacy, control, and flexibility. The names of the beneficiaries are not disclosed in public records. Beneficiaries maintain control over the property, and they can transfer their interest in the trust without public record changes. What are the benefits of land trusts? People often choose a land trust is the privacy it offers. Since the trustee holds the title, the names of the beneficiaries are not listed in public records, making it difficult for potential litigants to identify the true owners. Additionally, by placing property in a land trust, it becomes more challenging for creditors to seize your assets. Creditors may find it difficult to discover the existence of the trust or determine the property's value, deterring legal actions and settlement negotiations. Land trusts also simplify the process of transferring property ownership. Beneficiaries can transfer their interest in the trust without triggering a public record, useful for estate planning and avoiding probate. How does a land trust work? To establish a land trust, you need to create a trust agreement that outlines the terms and conditions. This document identifies the trustee, beneficiaries, and the powers and responsibilities of each party. An experienced attorney should draft the trust agreement to ensure compliance with state laws. The trustee holds the legal title to the property and manages it according to the trust agreement, while beneficiaries retain control and direct the trustee on property management actions. While land trusts offer numerous benefits, they also have potential drawbacks. They provide limited asset protection compared to other entities like LLCs or irrevocable trusts. Setting up and maintaining a land trust can be complex and may require ongoing legal assistance. Additionally, there may be tax implications, so consulting a tax professional is essential. Integrating land trusts with other strategies. To maximize asset protection, consider integrating land trusts with other legal entities like LLCs, which combine privacy with liability protection. Irrevocable trusts and Medicaid asset protection trusts can also enhance asset protection. Common uses of land trust. Land trusts are popular among real estate investors for anonymous purchases, streamlined transactions, and avoiding due-on-sale clauses. They are also valuable for estate planning, asset management for high net worth individuals, and charitable giving. To create a land trust, consult with an experienced attorney, select a reliable trustee, draft the trust agreement, transfer the property title, and maintain.
Welcome to our series on franchise law. Today, we're discussing the legal aspects of buying or starting a franchise. Understanding these aspects is crucial for making informed decisions and ensuring your business venture is successful. First, what is a franchise? A franchise is a business model where a franchisor grants a franchisee the right to operate a business using the franchisor's brand, products, and systems. The franchisee pays fees and agrees to operate the business according to the franchisor's guidelines. When considering a franchise, there are two primary legal documents you need to be familiar with: the Franchise Disclosure Document, or FDD, and the Franchise Agreement. The Franchise Disclosure Document, or FDD, provides detailed information about the franchisor and the franchise system. It includes the franchisor's history, litigation history, financial statements, initial and ongoing fees, and obligations of both parties. Reviewing the FDD thoroughly is essential. The Franchise Agreement is the binding contract between the franchisor and franchisee. It outlines the terms and conditions of the franchise relationship, including the rights and responsibilities of each party. Key terms to understand include the duration of the franchise, renewal terms, territorial rights, and conditions for termination. Conducting thorough due diligence is critical before buying a franchise. This involves reviewing the FDD, researching the franchisor's history and reputation, and understanding the financial commitments and projections. When buying a franchise, there are several legal considerations to keep in mind: initial franchise fees and ongoing royalties. Understand the total cost involved. Territorial rights and restrictions. Know your exclusive territory and any restrictions. Intellectual property rights. Understand your rights to use the franchisor's trademarks and proprietary systems. Obligations of the franchisor and franchisee. Clarify the support and training provided and expected. Renewal and termination clauses. Pay attention to the terms for renewing or terminating the agreement. Starting a franchise involves several key steps. Ensure legal compliance by registering your franchise and adhering to state-specific regulations. Develop an operations manual outlining how the franchise should be run. Protect your intellectual property by securing trademarks and trade secrets. Financial aspects are important. Explore financing options for buying or starting a franchise and understand the initial investment required, as well as ongoing expenses and royalties. Franchisee support and training are vital for success. Most franchisors provide initial training and ongoing support to help franchisees run their businesses effectively. Take full advantage of these resources. Disputes can arise in any business relationship. Common disputes in franchising include disagreements over territory, fees, and performance standards. Methods for resolving disputes include mediation, arbitration, and litigation. Address disputes promptly and seek legal advice if necessary. In conclusion, buying or starting a franchise involves navigating several legal aspects, from understanding the FDD and franchise agreement to conducting due diligence and ensuring legal compliance. Consulting with a qualified franchise attorney is essential to protect your interests and make informed.
The phrase life estate often comes up in discussions of estate and Medicaid planning. But what exactly does it mean? A life estate is a form of joint ownership that allows one person to remain in a house until his or her death, when it passes to the other owner. Life estates can be used to avoid probate and to give a house to children without giving up the ability to live in it. They also can play an important role in Medicaid planning, depending on your specific state. In a life estate, two or more people each have an ownership interest in a property, but for different periods of time. The person holding the life estate, the life tenant, possesses the property during his or her life. The other owner, the remainderman, has a current ownership interest but cannot take possession until the death of the life estate holder. The life tenant has full control of the property during his or her lifetime and has the legal responsibility to maintain the property as well as the right to use it, rent it out, and make improvements to it. When the life tenant dies, the house will not go through probate, since at the life tenant's death the ownership will pass automatically to the holders of the remainder interest. Because the property is not included in the life tenant's probate estate, it can avoid Medicaid estate recovery in states that have not expanded the definition of estate recovery to include non-probate assets. Even if the state does place a lien on the property to recoup Medicaid costs, the lien will be for the value of the life estate, not the full value of the property. If the property is sold, the proceeds are divided up between the life tenant and the remaindermen. The shares are determined based on the life tenant's age at the time. The older the life tenant, the smaller his or her share, and the larger the share of the remaindermen. Be aware that transferring your property and retaining a life estate can trigger a Medicaid penalty period if you apply for Medicaid within 5 years of the transfer. Purchasing a life estate should not result in a transfer penalty if you buy a life estate in someone else's home, pay an appropriate amount for the property, and live in the house for more than a year. In this video, we'll discuss how to protect your digital assets in your estate plan. With the increasing importance of digital assets, ensuring they are included in your estate planning is crucial. Digital assets are any electronic records that you own or control. These can include online banking accounts, social media profiles, email accounts, digital photos, cryptocurrencies, online businesses, and subscription services. Online banking accounts, social media profiles, email accounts, digital photos, cryptocurrencies, online businesses, subscription services. Why include digital assets in your estate plan? Including digital assets in your estate plan is essential to avoid several issues. Without proper authorization, your executors or loved ones may struggle to access or manage your digital accounts. This can lead to financial loss, especially with assets like cryptocurrencies or online business revenues. Additionally, unmonitored digital accounts can be vulnerable to identity theft. Lastly, sentimental items such as digital photos and videos can be lost forever without proper access. Here are the steps to protect your digital assets. First, create a comprehensive inventory of all your digital assets. Include account names, URLs, usernames, passwords, and backup codes. Next, understand the terms of service for each digital account. Different platforms have varying policies regarding access to accounts after the owner's death. Designate a digital executor. This person will manage your digital assets according to your wishes. Ensure they are tech-savvy and trustworthy. Include specific instructions for your digital assets in your will or trust documents. Ensure your financial power of attorney includes provisions for managing digital assets if you become incapacitated. Utilize online tools like Google's Inactive Account Manager and Facebook's Legacy Contact to manage access to your accounts. Secure your digital asset inventory using encrypted digital storage or physical copies in a safe. Regularly update your inventory and estate planning documents to reflect new accounts, changed passwords, or updated policies. Inventory your digital assets. Understand terms of service. Designate a digital executor. Include provisions in your estate plan. Utilize online tools, secure storage and backup. Regular updates. Digital assets pose unique legal challenges, especially about privacy laws and terms of service agreements. Work with a knowledgeable attorney to navigate these complexities. They can help draft clear instructions, ensure compliance with relevant laws, and avoid potential legal pitfalls. To protect your digital assets, it's essential to include them in your estate plan. By following these steps, you can ensure your digital legacy is preserved and accessible to your loved ones. Understanding special needs trusts. In this video, we will explain what a special needs trust is, its benefits, types, key considerations, and common mistakes to avoid. A special needs trust, or S&T, is a legal arrangement designed to manage assets for the benefit of a person with disabilities without disqualifying them from government benefits, such as Medicaid or Supplemental Security Income, known as SSI. The primary objective is to enhance the quality of life for the individual by providing financial support for needs not covered by government programs. Special needs trusts offer numerous benefits. They ensure that the beneficiary continues to qualify for essential government benefits, provide a steady source of funds for additional care, safeguard the beneficiary's assets from creditors, allow professional management of funds, and offer peace of mind to families. There are three main types of special needs trusts. First-party special needs trusts are funded with the beneficiary's own assets, such as an inheritance or a personal injury settlement. Third-party special needs trusts are funded by someone other than the beneficiary, typically parents or grandparents. Pooled special needs trusts are managed by nonprofit organizations and pool resources from multiple beneficiaries for investment purposes, while maintaining individual accounts for each beneficiary. When creating a special needs trust, there are several key considerations. Selecting the right trustee is crucial. They must be knowledgeable about public benefit programs and capable of managing the trust assets effectively. Funding the trust properly is also essential. with common sources including gifts, inheritances, life insurance policies, and personal injury settlements. The trust document must be carefully drafted to comply with legal requirements and protect the beneficiary's eligibility for government benefits. Regularly reviewing and updating the trust ensures it continues to meet the beneficiary's needs and complies with current laws. Avoiding common mistakes is important in maintaining the effectiveness of a special needs trust. Ensure the trust is adequately funded to cover long-term needs. Choose a trustee with the necessary expertise and commitment. Properly structure the trust to preserve government benefit eligibility and regularly update the trust to align with the beneficiary's evolving needs and changes in the law. Setting up a special needs trust is a compassionate and prudent step in securing the future for someone you care about. Medicaid provides health coverage to millions of Americans, including eligible low-income adults, children, pregnant women, elderly adults, and people with disabilities. Medicaid is administered by states according to federal requirements. The program is funded jointly by states and the federal government. The Medicaid system will pay for your care costs, including a stay in a nursing home if you meet certain qualifications. The Medicaid system has an asset limit. As of the day this video was produced, as an unmarried person in Wisconsin, you must have less than $2,000 in assets to qualify for Medicaid. If you have more than $2,000 of assets, you must first spend your assets on qualifying expenses until you drop below the asset limit. Once you drop below the asset limit, the Medicaid system will cover your costs. Assets are separated into two categories: countable and non-countable. Countable assets count towards the asset limit of $2,000. Some examples of a countable asset may include cash, your bank accounts, and stocks. Non-countable assets do not count towards the asset limit of $2,000. Some examples of a non-countable asset may include a first automobile, money prepaid for funeral expenses, or a primary residence if a spouse still resides in that home. One of the methods in pre-planning for Medicaid is to strategically turn your countable assets to non-countable assets. Doing this will help preserve the value of your assets, while dropping you below the asset limit, qualifying you for Medicaid benefits. We work with you to find the best methods and options of converting assets to non-countable assets to preserve the most value for you and fit your specific needs. Have you ever wondered what happens to someone's assets after they pass away? Today, we'll explore the world of probate, breaking it down into steps, as well as looking into the various types that are most appropriate depending on your circumstances. Dealing with assets after a loved one's passing is never easy, but understanding the process can help. Let's break down probate. What is probate? Probate is the formal legal procedure after someone's death, which settles their financial and legal affairs. It is the process that ensures assets are transferred rightly and legally to beneficiaries, and any outstanding debts are settled. But who ensures this process runs smoothly? The crucial role of the executor, that would be the executor, also known as the personal representative. They initiate the probate process, manage assets, settle debts, and ensure the rightful distribution of assets. It's a significant role, oftentimes demanding guidance from experienced probate attorneys. But how do you get started with probate? Let's walk through it step by step. Step 1. Initiating the probate process. Everything begins with appointing a personal representative, either named in the will or chosen by the court. They file a petition for probate, and here, professional legal guidance can be invaluable. Step 2. Inventorying the estate. The representative then takes stock of the deceased's assets, everything from real estate to bank accounts. Step 3. Settling debts and taxes. Before beneficiaries get anything, all debts and taxes must be settled using the estate's assets. Step 4. Distribution. Finally, the remaining assets are distributed according to the will or state laws if there's no will in place. Probate isn't one size fits all. There are different types for varying circumstances. Types of probate. Formal probate. This structured, judge-overseen process is ideal for complex estates or when beneficiaries have disputes. Informal probate. A simpler, quicker process fit for straightforward estates with a valid will and no disputes. Special administration. This method is for when immediate action is required or when full estate administration isn't necessary. Probate may seem complex, but with experienced guidance, you can be sure your estate is managed properly. Be sure to check out additional articles on probate or inquire about a consultation on the Heritage Law Office website in the description.
If you die without a will, the government decides who gets everything you own. Yeah, everything. Estate planning isn't just for the rich or the old. If you have a bank account, a car, a pet, or a kid, this is for you. Here are 3 things every adult needs: a will, a power of attorney, and a healthcare directive. And no, it doesn't take months. You can set this up in a short period of time. Without a plan, your loved ones could face court delays, legal battles, and stress right when they're grieving. Don't leave a mess. Start your estate plan today. Even a basic plan is better than nothing.
When you gift your home to your children, if they ever sell the house, they are responsible for paying taxes on the value gained during their ownership, as well as the value gained during your ownership. For example, if you bought a house for $100,000 and it is now worth $200,000, when your children sell the house, they will owe capital gains taxes on the $100,000 value gained, as well as any value gained during their ownership. However, assets that are left to heirs receive a step-up in cost basis. A step-up in basis adjusts the value of an asset when it passes from an owner to their heir at death. This means the value the house has gained during your ownership will not be subject to capital gains taxes when the property is sold. In the same scenario, if your children receive the $200,000 value house as an inheritance, upon selling the house, they will now only owe capital gains taxes for value added to the house during their ownership, instead of the value gained during your ownership as well. A house can benefit from the step-up in basis by passing the assets through a will, life estate, or trust. Probate is the process of administering the estate of the person who passed by gathering their assets, paying their liabilities, and distributing the remaining assets to the beneficiaries. You may ask, why should I avoid probate? The answer is simple: time and money. The probate process can be cumbersome and take significant time and money. However, the probate process can be avoided. Trusts, when properly set up and funded, can avoid probate. The question is, does a will avoid probate? No. Assets controlled by a will do not avoid probate. A will by its nature directs the assets through the probate process for administration and ultimate distribution to the beneficiaries. There are a number of ways to avoid probate. First, you can give away all your money and assets, so you have nothing to pass along. Second, you can add a joint owner to your assets or add a payable or transfer on death designee to your accounts. Third, you can establish a life estate on your property. Finally, you can avoid probate with a trust. Adding a joint owner or adding a payable or transfer on death designee is a simple solution. However, they do not offer the same benefits as a trust. Adding a joint owner or adding a payable on death or transfer on death designee does not offer asset protection for beneficiaries, can potentially cause a loss of government benefits for a beneficiary with a disability or special needs, and does not help with potential future incapacity. With a life estate, you do not own entire interest in the property. The interest in the property is split into 2 pieces: the current interest and the interest the other owner, the remainderman, has after your passing. Additionally, if you wish to sell the property, you can only sell the portion you own, your life estate, and you would need permission from the remainderman to sell the entire interest. A properly set up and funded trust can solve these issues. A trust can give possible asset protection for beneficiaries. With a trust, you can retain control of assets. A trust has the ability to protect beneficiaries with disabilities or special needs. Finally, a trust can plan for incapacity. The only downside of a trust is the initial setup.
Did you know there's a legal hack in estate planning that can save your family thousands without changing your will or trust? It's called transfer on death designation, or TOD, and almost no one talks about it. Here's how it works. You can add a TOD designation to your bank accounts, investment accounts, and even your car title in some states. When you pass away, those assets go directly to your chosen beneficiary. No probate, no court delays, no lawyer fees. It's as simple as filling out a form with your bank or DMV. That's it. And the best part? It costs nothing to set up. So if you want to protect your family from months of court headaches and thousands in legal fees, look into TODs today. Follow for more estate planning tips that actually save you money.
In this video, we will discuss the benefits of a living trust and how it can be a powerful tool in your estate planning strategy. A living trust, also known as a revocable trust, allows you to manage your assets during your lifetime and dictate how those assets will be distributed after your death. One of the key benefits of a living trust is avoiding probate. Probate is the legal process of distributing a deceased person's assets under court supervision. By placing your assets in a living trust, you can ensure a smoother, quicker distribution to your beneficiaries, saving time, reducing costs, and maintaining privacy. Another significant advantage is the control a living trust provides over your assets. You can manage your assets during your lifetime and specify exactly how and when your assets will be distributed after your death. This flexibility allows you to tailor the distribution to meet your beneficiaries' needs, such as staggering distributions for younger heirs. A living trust also includes provisions for managing your affairs if you become incapacitated. If you are unable to manage your assets due to illness or injury, your successor trustee can step in without the need for a court-appointed conservatorship, ensuring continuous management of your affairs. Flexibility is another key benefit of a living trust. You can amend or revoke the trust at any time while you are alive and competent, allowing you to adapt your estate plan as circumstances change. While a living trust alone does not provide estate tax benefits, it can be part of a comprehensive estate plan designed to minimize estate taxes. By integrating strategies such as irrevocable trusts or gifting, you can reduce the taxable value of your estate. A living trust can also protect your beneficiaries. This is especially beneficial for minors, individuals with special needs, or those who may struggle with financial management. Special needs trusts and spendthrift provisions within a living trust can ensure that your beneficiaries are protected and their inheritance is managed wisely. For business owners, a living trust can streamline the transfer of business ownership, ensuring a smooth transition and continuity of operations. This helps prevent disputes and ensures the business continues to operate effectively. Finally, administering an estate through a living trust is generally simpler and less burdensome for your trustee compared to probate. This results in lower administrative costs and a more straightforward process for managing and distributing your assets. In summary, a living trust offers numerous benefits, including avoiding probate, maintaining control over your assets, managing incapacity, flexibility, reducing estate taxes. A life estate is a form of joint ownership that allows one person to remain in a house until his or her death, then it passes to the other owner. Life estates can be used to avoid probate and to give a house to children without giving up the ability to live in it. They also can play an important role in Medicaid planning. In a life estate, two or more people each have an ownership interest in a property, but for different periods of time. The person holding the life estate, the life tenant, possesses the property during his or her life. The other owner, the remainderman, has a current ownership interest but cannot take possession until the death of the life estate holder. Many seniors enjoy the opportunity to be generous to their children by gifting them monetarily. In certain circumstances, however, there is a real concern that people who may be in need of long-term nursing care in the near future should not give gifts. It can be complicated trying to adequately plan for long-term care and consider gifting. In Wisconsin, for Medicaid to cover the huge expense of nursing home care, seniors must show that they own nothing more than around $2,000. And they must also show that they have not given away money or assets over the prior 5 years. The look-back period, or the transfer penalty, would charge that senior for their generosity. Depending on the size and number of the gifts, the penalty could be substantial. Many wrongly think that there is no penalty for gifts of up to around $15,000 annually. That misunderstanding confuses tax law with Medicaid law. The Medicaid rules are entirely different from the tax rules. In the Medicaid context, gifts of any amount that are given during the look-back period can be penalized. There are exceptions, including gifts to spouses and siblings under certain circumstances, disabled children, and children who are caregivers and who live at home with the elder for a span of time. But overall, gifts and Medicaid do not belong together. The Medicaid rules are complicated, and the consequences for mistakes can be very costly. There are a number of options to protect assets and still qualify for benefits, but these options must be weighed with great care. This is why it's best to consult attorneys who are experts in Medicaid law. Many people ask, should you put your house in a trust? The answer is probably yes, and in certain situations, the answer is a resounding yes. One of the wonderful things about revocable living trusts is there are very few downsides. If you are not familiar with a revocable living trust, think of a trust as a bucket. The bucket can hold your assets and contain a set of rules and instructions for what happens with the assets upon your passing. In that respect, the trust can function like a will. A revocable living trust has many benefits over a will, which may make placing your house. It is necessary to initiate a court procedure known as probate. Probate can be a cumbersome and time-consuming process. However, a properly designed revocable living trust has the luxury of being administered in the privacy of your own home or your attorney's office, rather than in the courtroom. This process is private, quicker, and oftentimes significantly less expensive compared to probate. A revocable living trust can avoid the probate process, saving time and money. If you own property in multiple states, such as Minnesota and California, a revocable living trust becomes even more valuable. With a revocable living trust, you will not have to open multiple probates across the different states. Moving your house to a revocable living trust is beneficial in most circumstances. This often raises the question, will a transfer of my home to a trust protect my home from creditors or nursing home expenses? With a revocable living trust, the answer is no. However, another type of trust, an irrevocable trust, may be able to provide you with protection for your home. Moving the house to an irrevocable trust has the result of removing it from your estate. This means it is no longer your asset from a legal standpoint. The house is owned by the irrevocable trust itself, similar to how a corporation can own an asset. Since you no longer own or have control of the asset, the home may be able to be protected from creditors or if you want to apply for Medicaid. Both revocable and irrevocable trusts are important parts of proper estate planning. However, for trusts to function, they must be used and set up properly. Improper use can have a substantial negative effect on your estate.
Step-by-step guide to creating a comprehensive estate plan. In this video, we will discuss how to create a comprehensive estate plan, covering key steps and common mistakes to avoid. Creating an estate plan is crucial to ensure your assets are distributed according to your wishes and your loved ones are taken care of after you're gone. Let's start by looking at the key components of an estate plan. First, we have wills. A will is a legal document that specifies how your assets will be distributed after your death and can also name guardians for minor children. Next, we have trusts. Trusts can help avoid probate, reduce estate taxes, and manage your assets if you become incapacitated. There are various types of trusts, including revocable, irrevocable, and charitable trusts. Powers of attorney are another important component. These documents allow you to appoint someone to manage your affairs if you are unable to do so. Healthcare directives, such as living wills and healthcare powers of attorney, let you specify your healthcare preferences and appoint someone to make medical decisions on your behalf. Beneficiary designations on assets like life insurance policies and retirement accounts take precedence over what's stated in a will, so keeping them up to date is crucial. For business owners, business succession planning ensures a smooth transition of your business after your death. Now, let's go through the steps to create an estate plan. First, assess your assets. Make a comprehensive list of everything you own, including real estate, bank accounts, investments, and personal property. Next, determine your goals. Identify what you want to achieve with your estate plan, such as providing for your family, minimizing taxes, and making charitable donations. Consulting an experienced attorney is crucial to ensure your estate plan is legally sound and tailored to your needs. Draft your documents, including your will, trusts, powers of attorney, and healthcare directives, and ensure they are properly signed and witnessed. Regularly review and update your estate plan, especially after major life events, to ensure it remains current and effective. Communicate your plan to your naming contingent beneficiaries can create issues if your primary beneficiary predeceases you or is unable to inherit. Choosing the wrong executor or trustee can lead to mismanagement and disputes. Select someone responsible and capable. Not considering long-term care needs can deplete your assets. Plan for potential long-term care expenses. Lack of coordination with financial plans can undermine your estate plan. Ensure your estate planning documents align with your financial goals. Neglecting to plan for business succession can disrupt your business. Create a clear plan for what will happen to your business after your death. There are additional considerations to enhance your estate plan. Charitable giving can provide tax benefits and support causes you care about. Special needs planning ensures your loved ones with special needs are provided for without jeopardizing their eligibility for government benefits. Pet trusts ensure your pets are taken care of after you're gone. Estate tax planning is essential for larger estates to minimize the impact of estate taxes. Digital estate planning includes your online accounts and digital currencies to ensure they are accessible and managed properly. Creating a comprehensive estate plan is a crucial step in protecting your legacy and providing for your loved ones. Contact a professional to help you navigate this complex process with confidence and peace of mind.
A trust is a legal document that acts like a bucket to hold assets and contain a set of rules and instructions. The person in charge of that bucket is called the trustee. There are several types of trusts, such as a revocable trust, an irrevocable trust, a pet trust, a charitable remainder trust, and more. A charitable remainder trust is an irrevocable trust that provides the donor with income for life and a current tax benefit for planning to donate assets upon their death. The donor gives away assets to an irrevocable trust, and during their lifetime they receive income from the trust. When they die, the remainder in the trust goes to the charities of their choice. When an asset is transferred into an irrevocable trust, it is removed from their estate. As a result, the assets in the trust cannot be recovered by creditors, and no estate taxes will be due upon their death. Additionally, because the assets are no longer owned by the donor, other advanced estate planning methods may be used in conjunction with a charitable remainder trust. Finally, for their generosity, the donor will receive an immediate income tax deduction when the charitable remainder trust is funded. The tax deduction amount is based on the current value of the assets that will go to charity. Irrevocable trusts are complex and must be precise. Be sure to talk with a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional. Life is full of surprises, new relationships, growing families, and unexpected financial windfalls. But have you ever wondered how these life events, affect your last will and testament? You're not alone. Delaying the update of your will can cost you dearly, leading to potential asset disputes, loss of money, and legal headaches for your Option 2. Revocation by destruction. Physically destroying the old will and all copies through means such as burning, shredding, or ripping out the signature. Note that this method does not permit the removal of specific provisions for change or termination. Instead, destruction through a physical act invalidates the entire will. It is still a good idea to include a revocation clause in the new will to clearly state your intentions and avoid any potential legal disputes or confusion. The second approach to modifying a will is by drafting a codicil. A codicil is a supplementary document that makes changes to an existing will. Like a regular will, codicils must show testamentary intent and satisfy all other requirements for validity. However, this method is not preferred because it leaves the person making the will with two legal documents. If one of them is lost, it could lead to potential challenges to the will, as codicils are not intended to serve as standalone wills. Now that you've updated duplicates, and include a note indicating the location of the original will, and provide a copy to a select few trusted individuals. Although you are not required to give anyone a copy, it's a good idea to leave one with the attorney who drafted the will. Have you taken any steps to secure and protect your will, and do you have any unique methods or additional precautions that you would like to share with the community? Let us know down below. And if you find this video informative and helpful, please give it a thumbs up. It really helps the channel out. Finally, our last question: when should I change my will? Estate planning is an ongoing process, and it's a good idea to revisit the terms of your will at least once a year, even if only to reaffirm them. However, certain life events may necessitate changes to your will, including divorce, marriage or remarriage, the birth of a new child, grandchild, or the addition of stepchildren, a serious and permanent falling out with a beneficiary, receiving a significant amount of property or money since your last will update, and relocating to a state with different marital property laws. Pause here for the full list. Failing to update your will after these events could lead to unintended consequences, such as assets being distributed to an ex-spouse rather than your current spouse or children, disinheriting a child or grandchild accidentally, leaving your estate to people you no longer have a relationship with, or by unintentionally excluding new family members, and a lengthy legal battle among your loved ones to determine your true intentions. Pause here again for the full list. It's crucial to keep your will up to date as your life circumstances and intentions change. Otherwise, you risk putting your family and loved ones through unnecessary stress and legal complications. Whether you choose to draft an entirely new will or amend your existing one with a codicil, it's essential to follow the proper legal procedures to ensure your wishes are honored. Don't hesitate to explore our extensive collection of in-depth articles, insightful guides, and useful resources at heritagelawoffice.com. If you found this video beneficial, you're sure to appreciate our next video. Pass down your home tax-free, recommended right here. Don't miss out, it's packed with useful information. Don't forget to like and subscribe to this channel for more beneficial videos in the future. Thank you for joining us, and we look forward to helping you protect your family's legacy. In this video, we'll explore how to choose the right executor for your estate, covering key considerations and steps to ensure your wishes are carried out. Choosing the right executor is a crucial part of estate planning. Your executor will manage your affairs, settle debts, and distribute your assets according to your will. Making an informed choice can provide peace of mind for you and your loved ones. An executor has several key responsibilities. They collect and manage assets, pay debts and taxes, and distribute assets to beneficiaries. They must act prudently, be impartial, and maintain detailed records. When choosing an executor, look for trustworthiness and integrity. Your executor should be someone you trust implicitly and who has a reputation for honesty. Financial acumen is also essential, especially if your estate includes complex assets. Organizational skills are crucial, as the executor must handle numerous documents and deadlines. They should also be able to handle stress and make sound decisions under pressure. Availability is another key factor, as the role can be time-consuming. Common choices for executors include family members, friends, and professionals. Family members and friends may have a personal interest in honoring your wishes, but it's important to consider their potential emotional strain and conflicts of interest. Professionals, such as lawyers or trust companies, offer expertise and impartiality but come with costs. Consider the size and complexity of your estate when choosing an executor. A large or complicated estate might benefit from a professional executor. Also, think about family dynamics and whether the person you choose can navigate potential conflicts. Geographical proximity can be beneficial, especially if your estate includes real property. Legal requirements vary by state, but generally, an executor must be of legal age, of sound mind, and free of felony convictions. Some states require executors to post a bond to protect the estate from potential mismanagement. You may also appoint co-executors to share responsibilities, but this can lead to conflicts if they disagree. Alternatives to traditional executors include corporate trustees, who provide professional management, and successor executors, who step in if your first choice is unable to serve. To formalize your choice, include your executor in your will, clearly stating their name and any specific instructions. Communicate your decision with your chosen executor and any successors, and review your will periodically to ensure it reflects any changes in circumstances. Avoid common mistakes, such as choosing an executor out of obligation, overlooking professional help, and ignoring potential conflicts of interest. Make a choice based on suitability for the role. Choosing the right executor requires careful consideration and foresight. To ensure your choice is legally sound and well-informed, consult with an experienced attorney. They can guide you through the process and help you select the best candidate for your needs. In many families, it's customary to pass on the family home to surviving children after the parent's death. You may be considering how to give your child or children your home without the sting of taxes later. It is possible, and there are a few ways to accomplish it, but it takes some advanced planning to make sure everything happens in a way that provides the most benefits to your family. You may be concerned about Medicaid taking your house or spending down your assets to receive Medicaid benefits. Estate recovery occurs after your death, when the state goes through your assets to recover costs of your long-term nursing home care while you were alive. Since a house is often the only major asset many individuals have, frequently the home is sold and the funds are used to repay Medicare. However, you can protect your home from a Medicaid estate recovery and sale. One way to pass a home to your child or children is to make a will and designate a beneficiary for your home in your newly created will. Although estate recovery issues need to be considered using this method, taxes can generally be reduced or eliminated as individuals receiving property upon the death of another are entitled to an adjustment in the cost basis, a step up, when there are built-in gains. Gifting the family house to children has consequences that are often unforeseen by families looking to safeguard their assets. Making such a transfer puts you in a difficult position if your children go through divorce, bankruptcy, incur liability due to a lawsuit, or other financial problem occur that may require reselling the house. If you're planning to move out of the house now, you can give the property to your child. However, attorneys generally have better techniques than making such a transfer. A life estate allows you to transfer part ownership to your children, or anyone else, while you're alive. You can live in it, or rent it out, during your lifetime, and when you die, the remaining ownership passes to your kids or others to whom the asset was transferred, who may then take full possession and ownership of the assets. Placing the home in an irrevocable trust with your children as the beneficiaries is another option. Doing so may help you avoid estate taxes, qualify for Medicaid for nursing home or assisted living facility expenses, and protect the house from Medicaid estate recovery. Careful planning is a must, as making a transfer to an irrevocable trust may cause an ineligibility period for Medicaid for a period of time after such a transfer of your home. If the house is eventually sold, the proceeds remain in the trust, and the proceeds of the sale will be passed to the trust beneficiaries. If you gift a piece of real estate directly to your child or grandchild, it is perceived as a gift by the IRS. You cannot claim a loss, nor is your gift tax deductible. You can gift a maximum of $15,000 in 2018, but gifting more does not necessarily warrant the payment of taxes, however. A trust is a legal document that acts like a bucket to hold assets and contain a set of rules and instructions. The person in charge of that bucket is called the trustee. There are several types of trusts, such as a revocable trust, an irrevocable trust, a pet trust, a charitable remainder trust, and more. An asset protection trust is a type of trust that is designed to protect a person's assets from claims of future creditors. Asset protection trusts are normally structured so that they are irrevocable and so that the trust maker is not a current beneficiary. If the asset protection trust is properly structured, the assets inside of the trust will not be able to be accessed by creditors. Often, asset protection trusts are used to help make you eligible for Medicaid by reducing the assets in your name, as well as reducing or eliminating the amount that can be recovered by Medicaid after your passing. Asset protection trusts are very precise and complicated and should be completed by a professional. All forms of trusts are important asset planning and protection tools that have their specific place.
For less than the cost of 1 month in a nursing home, this strategy can protect your entire life savings. The cost of nursing home care can be overwhelming, often exceeding $9,000 per month. Medicaid rules require that your assets fall below a certain limit before you can qualify for free nursing home care. This asset limit is often shockingly low, $2,000 in many states. This means you'll have to deplete your entire life savings before you can receive assistance. However, there is a solution: an irrevocable trust. By creating an irrevocable trust and transferring your assets into that trust, you can set aside and protect assets and qualify for Medicaid. When you transfer your assets into an irrevocable trust, the assets are no longer considered yours. The trust owns the assets. This means if you transfer your assets into this trust and you fall within the Medicaid eligibility limits, you can qualify for Medicaid without spending down your life savings. By using this strategy, you can qualify for free nursing home care while your assets in the irrevocable trust are protected and set aside for your loved ones. However, it's important to note the 5-year look-back period. Medicaid reviews your financial transactions for the past 5 years, and any transfers made during this period could result in an ineligibility period. Assets transferred longer than 5 years ago do not affect your eligibility. If you expect to require nursing home care within 5 years, you can still benefit from this type of estate planning, but the results are much more limited than if you planned at least 5 years ahead. Therefore, planning ahead is crucial. Start planning today to protect your hard-earned assets.
Is it better to use joint ownership or a trust to pass down a home? You may be wondering about how to pass your home to your spouse, children, or other beneficiaries after you die. A will works, but that will require them to go through the probate process, which may take a considerable amount of time and money. There are estate plan alternatives that allow the bypass of the probate process to ensure a faster, easier transition that will also be less expensive for the beneficiary. A will is just one way to pass along your house. Joint ownership and revocable living trusts allow you to pass along your home, live in it while you're alive, and make sure your assets go where you want them to. joint ownership and revocable living trusts are not necessarily replacements for a will. You should still create a will as a backup to carry out final wishes and pass along any other property that isn't in a trust or other probate avoidance. What is joint ownership? If you and your spouse or anyone else jointly own a house and the right of survivorship is included in that ownership, the house will automatically pass to the other individual upon your death without probate. Your spouse will be required to file paperwork to claim ownership. Wisconsin offers two types of joint ownership. Number 1, joint ownership, where 2 or more parties own an equal share. This works well for couples who acquire property together and each owns a half interest. However, this will not avoid probate for the remaining party, or if the 2 parties were to die simultaneously. Number 2, survivorship marital property, known in other states as community property, where the surviving spouse inherits any joint property. This does not include any property that's not part of the marital estate, such as anything kept as separate property. What does using a revocable trust mean? A revocable living trust is created while you're alive, and revocable because you can make changes as you wish as long as you're able to. This written document can be used for your house as well as other assets, such as bank accounts, other real estate, and vehicles. A minimum of 3 parties participate in a trust. The settlor or grantor who creates the trust, your spouse may also be a trustee. The trustee, the person or persons who accept the property from the trust and manage it according to the trust. That's you while you're alive, and whomever you assign after you die. You can have multiple co-trustees if you like. Beneficiaries are the individuals who receive income from the trust's property, and if directed, the property as well. There are advantages and disadvantages to both options. Joint ownerships and trusts are available to anyone but aren't a one-size-fits-all option. An experienced estate planning attorney who understands both can help you decide which one is right for your specific circumstances. How to save over $100,000 through Medicaid planning. Nursing home costs are expensive and add up quickly. Within a short period of time, an entire life savings can be depleted by paying for the cost of a stay in a nursing home. With proper planning, however, substantial value may be able to be preserved and passed along. Here is an example of how to save over $100,000 through active Medicaid planning. Mary has a savings account worth $75,000 and an investment account worth $150,000, totaling $225,000. Mary will be requiring nursing home care starting next month. Nursing home expenses are $10,000 per month. Since Mary did not previously buy long-term care insurance or pre-plan, Mary will have to cover the costs out of pocket. Mary will have to pay out of the savings account and liquidate the investment account to pay for nursing care. In less than 2 years, Mary will be completely out of money. Medicaid is administered by states according to federal requirements. State rules may vary. For example, in Wisconsin, the Medicaid rules are structured so that once you have less than $2,000 in assets, Medicaid will pay for a required nursing home stay. Now that Mary has spent $225,000 and is out of money, public benefits will pay for Mary's nursing home care. Most people struggle with the concept of seeing their entire life savings depleted very quickly. They would prefer to transfer those assets to their children, family members, friends, or donate that money to charity, rather than seeing the money depleted. The easy solution seems to be to give away all your assets to drop below the asset limit and qualify for Medicaid. It is not that easy. Medicaid will not allow you to gift away all your assets and immediately qualify for Medicaid benefits. When gifting assets, Medicaid imposes a divestment penalty, causing an ineligibility period for Medicaid, time that must pass before public benefits will pay for nursing home expenses. The larger the value of the gift made, the longer the ineligibility period. The ineligibility period only starts counting down when you apply for Medicaid, and you would be otherwise eligible if the ineligibility period did not exist. At the time of this video, in Wisconsin, for every $303.38 given away, 1 day of Medicaid ineligibility is assessed. If Mary were to give away all her money, then apply for Medicaid, she would be ineligible for 2 years after applying and must find funds to pay for nursing home expenses. Here's one possible way to solve this issue. Again, there are different rules in different states, so be sure you talk to a professional. Mary has a total of $225,000. Mary splits the money into 2 different pieces. One that Mary keeps and turns into a stream of income, and one that Mary gives away to her family, friends, or charity. In this example, Mary converts $118,000 to a stream of monthly income. Income is treated differently than assets and do not count towards the Medicaid asset limit in Wisconsin. Mary receives the money back in equal payments over 12 months as income. We will discuss what Mary does with this cash flow in just a bit. Mary also gives away the remaining $107,000, either to individuals or to a special type of trust, an irrevocable trust. We believe an irrevocable trust is generally a better option for numerous reasons, which we will discuss in a separate video. At this point, Mary has no money remaining. She has gifted $107,000 to family, friends, or a trust, and has spent $118,000 to acquire a monthly income stream. Giving away money is considered a gift, causing a divestment period where Mary is ineligible for Medicaid benefits for a period of time. In Mary's scenario, a gift of $107,000 will cause an ineligibility period of 352 days. Now that Mary has less than $2,000, Mary can apply for Medicaid. Mary will be assessed an ineligibility period due to the $107,000 gift. However, the ineligibility period will now start counting down, and Mary will be eligible for coverage at the end of the 352-day ineligibility period. During the ineligibility period, Mary will use the monthly income stream to pay the nursing home expenses. That stream of income will expire the same time as Mary's ineligibility period, leaving Mary with less than $2,000 during the ineligibility period and when the ineligibility period ends. At the end of the ineligibility period, the income stream will stop, and Medicaid will cover Mary's nursing home expenses. Meanwhile, the assets that are set aside in the trust or gifted to individuals are saved. They are not subject to being spent on nursing home expenses. Rather than spending $225,000 on nursing home expenses and having the entire value of the assets depleted, $107,000 were able to be passed on to friends, family, or charity. Our next video will be about how Mary could have saved almost all of the $225,000 with proper Medicaid pre-planning. Medicaid planning and Medicaid applications are complicated, precise, and vary state to state. One mistake can be very costly. A trust is a legal document that acts like a bucket to hold assets and contain a set of rules and instructions. The person in charge of that bucket is called the trustee. There are several types of trusts, such as a revocable trust, an irrevocable trust, a pet trust, a charitable remainder trust, and more. A special needs trust is a type of trust that gives an individual with special needs access to funds in the trust without losing benefits provided by public assistance programs. Public assistance programs set up for people with special needs are generally predicated on income and asset limitations. The limitations may be surprisingly low in your state. However, money or assets that belong to the Special Needs Trust generally do not count toward the purpose of qualifying for public assistance. By properly setting up and funding a Special Needs Trust for the individual with special needs, they will have additional funds from the trust while still qualifying for public benefits. improperly setting up or funding a special needs trust will generally result in loss of assets or loss of public benefits. Consult with a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional. One way to pass a home to your child or children is to make a will and designate a beneficiary for your home in your newly created will. Although estate recovery issues need to be considered using this method, taxes can generally be reduced or eliminated as individuals receiving property upon the death of another are entitled to an adjustment in the cost basis, a step up when there are built-in gains. Gifting the family house to children has consequences that are often unforeseen by families looking to safeguard their assets. Making such a transfer puts you in a difficult position if your children go through divorce, bankruptcy, incur liability due to a lawsuit, or other financial problem occur that may require reselling the house. If you're planning to move out of the house now, you can give the property to your child. However, attorneys generally have better techniques than making such a transfer. A life estate allows you to transfer part ownership to your children or anyone else while you're alive. You can live in it or rent it out during your lifetime, and when you die, the remaining ownership passes to your kids or others to whom the asset was transferred, who may then take full possession and ownership of the assets. Placing the home in an irrevocable trust with your children as the beneficiaries is another option. Doing so may help you avoid estate taxes, qualify for Medicaid for nursing home or assisted living facility expenses, and protect the house from Medicaid estate recovery. Careful planning is a must, as making a transfer to an irrevocable trust may cause an ineligibility period for Medicaid for a period of time after such a transfer of your home. If the house is eventually sold, the proceeds remain in the trust, and the proceeds of the sale will be passed to the trust beneficiaries. If you gift a piece of real estate directly to your child or grandchild, it is perceived as a gift by the IRS. You cannot claim a loss, nor is your gift tax deductible.
In this video, we will explore the essential differences between trusts and wills and answer some common questions to help you understand these important estate planning tools. A will is a legal document that outlines how your assets will be distributed after your death. It must go through the probate process, which can be time-consuming and public. A trust, on the other hand, is a legal arrangement where one party holds and manages assets on behalf of another. Trusts can often avoid probate, providing a quicker and more private way to distribute assets. So, do you need both a will and a trust? The answer depends on your unique circumstances. Wills are crucial for naming guardians for minor children and specifying final arrangements. Trusts, however, can manage and distribute assets efficiently and provide benefits during your lifetime, especially if you become incapacitated. Having both can ensure comprehensive coverage for your estate. Now let's look at the different types of trusts and their benefits. Revocable trusts or living trusts can be altered during your lifetime and help avoid probate. Irrevocable trusts, which cannot be changed once established, offer asset protection and tax benefits. Charitable trusts support philanthropic goals and provide tax deductions. Testamentary trusts are created through a will and take effect upon your death. Special needs trusts ensure care for a beneficiary with special needs without affecting government benefits. Medicaid asset protection trusts help protect assets for Medicaid eligibility. Trusts can also be an effective tool for minimizing estate taxes. Irrevocable trusts, for instance, remove assets from your taxable estate, potentially reducing your estate tax burden. Charitable trusts can provide both estate tax benefits and charitable deductions. Specialized trusts like grantor retained annuity trusts, or GRATs, and qualified personal residence trusts, or QPRTs, can also help reduce estate taxes. However, not all assets can be placed in a trust. Retirement accounts like IRAs and 401ks typically cannot be transferred into a trust without triggering taxes. Your primary residence can be transferred into a trust, but it requires careful planning to avoid losing homestead exemptions. While vehicles can be placed in a trust, it can be complex and might not be necessary. Choosing the right trustee or executor is crucial for the smooth administration of your estate. Look for someone trustworthy, with financial acumen, and who is available and willing to fulfill their duties. Impartiality is also important, especially in families where potential conflicts may arise. Professional or corporate trustees are an option if you do not have a suitable individual in mind. It's also essential to regularly update your will or trust. Major life events like marriage, divorce, the birth or adoption of a child, significant financial changes, or moving to a different state can impact your estate plan. Regular reviews with your attorney can ensure your documents remain up to date and effective. Understanding the differences between wills and trusts and knowing when to use each is vital for effective estate planning. Trusts and wills can work together to provide a comprehensive plan that addresses all. Welcome back to our series on estate planning. Today, we're going to discuss what's included in a comprehensive estate plan and why each component is important. Estate planning ensures your wishes are honored and your loved ones are protected after you're gone. A well-rounded estate plan includes several key elements. Let's explore each of them. First, let's talk about wills. A will is a legal document that outlines how you want your assets distributed after your death. It also allows you to name an executor to manage your estate and guardians for any minor children. Having a will ensures your assets are distributed according to your wishes and can help avoid disputes among your heirs. Next, we have trusts. Trusts are versatile tools that can help manage and protect your assets. There are different types of trusts, including revocable, irrevocable, and living trusts. Trusts can help avoid probate, manage your assets if you become incapacitated, and provide privacy. They can also offer tax benefits and protect your assets from creditors. A crucial part of any estate plan is a durable power of attorney. This document allows you to appoint someone to manage your financial affairs if you become incapacitated. The appointed agent can handle tasks such as paying bills, managing investments, and making financial decisions on your behalf. It's essential to choose someone you trust for this role. Healthcare power of attorney and a living will are also vital. A healthcare power of attorney lets you designate someone to make medical decisions for you if you're unable to do so. A living will outlines your preferences for medical treatment, such as life support or resuscitation. These documents ensure your medical care aligns with your wishes and relieves your loved ones from making difficult decisions in stressful times. Beneficiary designations are another critical component. Many assets, such as life insurance policies and retirement accounts, allow you to name beneficiaries. It's important to keep these designations up to date to ensure the assets go to the intended recipients. Regularly reviewing and updating your beneficiary designations can prevent complications and ensure your assets are distributed according to your wishes. A letter of intent can be a valuable addition to your estate plan. Although it's not a legally binding document, it can provide personal messages, burial instructions, and specific details about certain bequests. This letter helps clarify your wishes and provides guidance to your loved ones and executors. For those with minor children, guardianship designations are essential. Naming a guardian in your will ensures that your children are cared for by someone you trust if something happens to you. Consider the guardian's values, parenting style, and willingness to take on this responsibility when making your choice. In today's digital age, it's important to include digital assets in your estate plan. Digital assets can include online accounts, social media, digital currencies, and any digital property you own. Make a list of your digital assets and provide instructions on how to access and manage them. This ensures that your digital presence is handled according to your wishes. Regularly reviewing and updating your estate plan is crucial. Life events such as marriage, divorce, the birth of a child, or significant changes in assets can affect your plan. Keeping your estate plan up to date ensures it continues to reflect your wishes and adapts to your changing circumstances. Lastly, consulting with professionals is essential. Working with a qualified estate planning attorney, financial advisor, and tax advisor can help tailor your plan to your specific needs and ensure it's legally sound. These professionals can provide valuable guidance and ensure your estate plan is comprehensive and effective. In summary, a comprehensive estate plan includes a will, trusts, durable power of attorney, healthcare power of attorney, living will, beneficiary designations, letter of intent, guardianship designations, and provisions for digital assets. Regularly reviewing and updating your plan and consulting with professionals are key to ensuring your wishes are honored and your loved ones are protected. Welcome back to our series on estate planning for business owners. In our previous videos, we've covered the basics of business succession planning and how to create a robust succession plan. Today, we're going to explore how trusts can be used in business succession planning to ensure a smooth transition and protect your business assets. Trusts are powerful tools that can provide numerous benefits in business succession planning, including asset protection, tax efficiency, and control over how your business is transferred. Let's look at the different types of trusts and how they can be used in your succession plan. First, let's talk about revocable living trusts. A revocable living trust allows you to transfer ownership of your business and other assets into the trust while you're still alive. You can maintain control over these assets and make changes to the trust as needed. Upon your death or incapacity, the trust becomes irrevocable, and the successor trustee you've appointed can manage and distribute the assets according to your wishes, ensuring a seamless transition. Next, we have irrevocable trusts. Unlike revocable trusts, irrevocable trusts cannot be changed or revoked once they are established. These trusts can be beneficial for protecting your business assets from creditors and reducing estate taxes. By transferring ownership of your business to an irrevocable trust, you remove these assets from your taxable estate, which can provide significant tax savings for your heirs. One specific type of irrevocable trust that is particularly useful in business succession planning is the Irrevocable Life Insurance Trust, or ILIT. An ILIT holds a life insurance policy on the business owner. When the owner passes away, the life insurance proceeds go into the trust, providing liquidity to pay estate taxes or buy out a deceased owner's interest in the business. This ensures that the business can continue to operate smoothly without financial strain. Another important trust is the Grantor Retained Annuity Trust, or GRAT. A GRAT allows you to transfer business assets to a trust while retaining the right to receive an annuity payment for a specified term. After this term, the remaining assets in the trust are transferred to the beneficiaries, typically your heirs. This strategy can help minimize gift and estate taxes, making it an efficient way to pass on your business. Family limited partnerships, or FLPs, are also often used in conjunction with trusts. In an FLP, you can transfer business assets into a partnership structure, which is then owned by a trust. This can provide additional asset protection and facilitate the gradual transfer of business interests to your heirs while retaining some control over the business operations. Using trusts in business succession planning offers several advantages. Trusts can help avoid probate, ensuring a faster and more private transfer of your business. They can provide continuity of management by appointing a trustee to oversee the business until your successor is ready to take over. Trusts can also protect your business assets from creditors, lawsuits, and potential family disputes. However, setting up trusts can be complex and requires careful planning. It's crucial to work with a qualified attorney who has experience in both estate planning and business succession planning. They can help you choose the right type of trust for your situation and ensure it is structured properly to meet your goals. In summary, trusts are valuable tools in business succession planning. They offer benefits such as asset protection, tax efficiency, and control over the transfer of your business. By incorporating trusts into your succession plan, you can ensure a smooth transition, protect your business's value, and achieve your long-term goals. Thank you for watching.
Most people think once they've written a will, they're done. But here's the biggest mistake. They never update it. Life changes, fast. Got married, had a child, got divorced, bought a house. All of these are reasons to review your will. An outdated will can cause confusion, delays, or even get challenged in court. Set a reminder to check your will every few years, or any time your life changes. It's a simple habit that can save your family a lot of stress later.
In this video, we will explain personal trusts, their types, benefits, and how to create one. Stay tuned to learn how trusts can help you manage and protect your assets. A personal trust is a legal arrangement where a trustee holds and manages assets for the benefit of a beneficiary. The person who creates the trust, known as the grantor, transfers their assets into the trust. There are several types of personal trusts, each with unique benefits. Revocable trusts allow the grantor to retain control and make changes during their lifetime. This type of trust helps avoid probate, provides privacy, and can be amended as needed. Irrevocable trusts, on the other hand, cannot be altered once established. These trusts offer greater asset protection and tax benefits, but reduce the grantor's control over the assets. Charitable trusts benefit a charitable organization while providing tax advantages to the grantor. They support philanthropic goals and offer income tax deductions. Special needs trusts are designed for disabled beneficiaries, ensuring they receive financial support without affecting their eligibility for government benefits like SSI and Medicaid. Testamentary trusts are created through a will and take effect after the grantor's death. They are often used to provide for minor children and manage assets for dependents. Spendthrift trusts protect the beneficiary's inheritance by limiting their access to the trust principal, ensuring long-term financial support. Personal trusts offer several key benefits, including asset protection, tax efficiency, control and flexibility, privacy, and support for beneficiaries. Creating and managing a personal trust involves several steps. First, determine your goals and choose the type of trust that best meets your needs. Select a reliable trustee and work with an attorney to draft the trust document. Fund the trust by transferring ownership of your assets into it, and maintain the trust by complying with its terms and making necessary distributions. Personal trusts can be used for estate planning, asset protection, tax planning, long-term care planning, and business succession. Selecting the right trustee is crucial. Look for qualities like integrity, financial acumen, impartiality, and good communication skills. You can choose an individual trustee, a corporate trustee, or a combination of both as co-trustees. To recap, personal trusts are a powerful tool for managing and protecting your assets. They offer numerous benefits and can be tailored to meet your specific needs. If you're considering setting up a trust, contact a personal trust attorney to.
In this video, we will explore the responsibilities associated with a power of attorney and what you need to know as an agent or principal. A power of attorney, or POA, is a legal document that allows one person, known as the agent, to act on behalf of another person, called the principal. This authority can cover various aspects of the principal's life, depending on the type of POA granted. There are several types of power of attorney, each serving different purposes. A general power of attorney grants broad authority to handle financial and legal matters. The special or limited power of attorney restricts the agent's authority to specific tasks or situations. A durable power of attorney remains effective even if the principal becomes incapacitated, ensuring continuous management. A springing power of attorney becomes effective only under specific conditions, such as the principal's incapacitation. A financial power of attorney specifically grants the agent authority to manage financial matters, including banking, investments, and real estate transactions. And finally, a healthcare power of attorney allows the agent to make medical decisions on the principal's behalf. As an agent, you have several key responsibilities. You must always act in the principal's best interest, making decisions that align with their preferences and well-being. Managing finances is another crucial duty, which includes paying bills, managing investments, handling taxes, and budgeting. Keeping accurate records of all transactions and decisions made on behalf of the principal is essential. These records ensure transparency and accountability. If you have the authority to make healthcare decisions, you must choose healthcare providers, consent to treatments, and access medical records as needed. Agents must act within the scope of authority granted by the POA document. Any actions taken beyond this scope can be invalid. As an agent, you have a fiduciary responsibility to avoid conflicts of interest and refrain from benefiting personally from your role. You are also accountable for any misuse or mismanagement of the principal's assets. A power of attorney can end in several ways. The principal can revoke the POA at any time if they are mentally competent. The POA automatically ends upon the principal's death, with responsibility passing to the executor of the estate. Additionally, a court can terminate a POA if the agent is not acting in the principal's best interest. Understanding the principal's wishes is crucial, so regular and open communication is necessary. Staying organized with calendars, technology, and regular reviews of the principal's assets. Probate is the legal process that occurs to your estate after you pass away. During this legal process, a court will monitor the process of paying your debts and distributing your estate to the proper heirs. The probate process will take several months at minimum to complete and may take longer, depending on the complexity of your estate. Through proper planning, probate can be avoided, saving time and money. Tools such as a trust, life estate, joint ownership, and payable or transfer on death designations may be able to avoid probate. A will does not avoid probate as it is designed to go through the probate process. Here's how to avoid probate. If you pass away without proper pre-planning, your assets will likely go through probate. Probate is a court-supervised process for distributing your assets to your heirs. The process can be time-consuming and expensive, and it can tie up your assets for months or even years. What is probate? Probate is the legal process of distributing a deceased person's assets to their heirs. If the deceased person had a will, the court will follow the instructions in the will. If the deceased person did not have a will, the court will distribute the assets according to state law. The probate process can be time-consuming and expensive. It can also be stressful for the family members who are trying to settle the estate. The probate process can take months or even years to complete, and during that time, the assets of the estate are usually not available to the heirs. Why you should plan your estate to avoid probate. There are several good reasons to plan your estate to avoid probate. The probate process can be expensive. Probate can tie up your assets for a significant period of time. Probate is a public process, which means that anyone can access the documents filed with the court. If you don't want your assets to go through probate, you need to plan your estate carefully. There are several ways to avoid probate, including setting up a trust, transferring ownership of your assets to a beneficiary, or giving your assets away. How can you avoid probate? If you plan your estate carefully and properly, you can avoid probate altogether. One way to avoid probate is to create a trust. A trust is an arrangement in which property is held by one person, the trustee, for the benefit of another person, the beneficiary. Trusts can be used to avoid probate because the property in the trust does not go through probate when the trustor dies. Another way to avoid probate is to name a payable on death (POD) or transfer on death (TOD) beneficiary on eligible accounts. Assets that have a payable on death or transfer on death designee will not go through the probate process. Another way to avoid probate is to give away property during your lifetime. For example, you could give your assets to your children now instead of waiting until after you die. However, this may not be practical for everyone and may not have the best tax consequences for your children. Allowing your children to inherit assets allows them to benefit from a step-up in cost basis. Finally, some other estate planning tools, such as a life estate, may be available to avoid probate. There are many estate planning tools, each with their own uses. It is important to speak with an experienced estate planning attorney to find the proper tool for your individual situation. Thank you for watching this video brought to you by Heritage Law Office. If you found this information valuable and wish to learn more, don't forget to like.
In this video, we'll talk about what you need to know about the advantages and disadvantages of establishing a trust. If you're contemplating setting up a trust, this video is designed to help you make a more informed decision. Let's get started. What is a trust and why is it important? First, let's answer a common question. What exactly is a trust? A trust is a legal arrangement that allows a third party, called a trustee, to hold and manage assets on behalf of beneficiaries. Trusts are commonly used in estate planning, wealth management, and asset protection. They can help individuals achieve various financial and personal objectives, such as providing for loved ones, reducing taxes, or ensuring privacy. Now that you understand what a trust is, let's move on to explore the different types of trusts you can establish. There are many types of trusts, each serving a specific purpose. Some common types include revocable living trusts. Irrevocable trusts, testamentary trusts, special needs trusts, charitable trusts. Each type of trust has its own set of advantages. Let's take a closer look. Trusts offer a multitude of benefits. First, they give you significant control and flexibility over how your assets will be managed and distributed. You can establish specific terms and conditions, aligning your trust seamlessly with your unique goals and needs. Another major advantage is probate avoidance. Probate is a legal procedure that validates a will and distributes assets. Trusts, however, bypass this process entirely, enabling a faster and more confidential asset transfer to your beneficiaries. Tax benefits are also on the table. Some trusts can substantially minimize estate, gift, and income taxes. For instance, an irrevocable trust can effectively reduce your taxable estate, offering potential tax savings for your beneficiaries. Lastly, trusts are excellent tools for asset protection. They can shield your assets from creditors, lawsuits, or even divorce proceedings. While trusts offer significant advantages, it's essential to also consider the disadvantages. Complexity and cost. Even though trusts are highly beneficial, they come with some drawbacks. The most glaring ones are their complexity and associated costs. Establishing a trust requires experienced legal guidance, and there may be some administrative fees involved. Additionally, some trusts, particularly irrevocable ones, lack flexibility. Once established, they can't be easily changed or dissolved without the beneficiary's consent. Finally, trusts can sometimes fuel conflicts among family members or beneficiaries, especially if the trust is perceived as unfair or if the trustee is not acting responsibly. Understanding both sides of the coin can help you make a well-informed decision about whether a trust is right for you. A trust can offer numerous advantages, such as control over asset distribution, probate avoidance, potential tax benefits, and asset protection. However, there are some drawbacks to consider, like the complexity and cost of establishing and maintaining the trust, potential irrevocability, and the possibility of conflicts among beneficiaries. For more information on each type of trust, explore some of our other videos where we break these down individually.
Here's one important catch when it comes to gifting your home. If you gift the home during your lifetime, your heirs inherit the original cost basis. This means they'll have to pay capital gains taxes on the appreciation since the day you bought the home, not the day they inherited. Let's say you bought your home 30 years ago for $200,000, and today it's worth $1 million. If you gift it to your child now, they inherit your $200,000 cost basis. If they sell it for $1 million, they'll owe capital gains taxes on $800,000. However, if they inherit it after your passing, the cost basis steps up to the home's current market value of $1 million, meaning they could sell it tax-free. This is why, for many families, holding onto your home and passing it through inheritance, especially with a trust, can be a smarter move than gifting it early.
Welcome to our series on estate planning. Today, we're going to discuss digital estate planning and how to manage your digital assets and online accounts in your estate plan. In our digital age, it's crucial to include these assets in your planning. First, what are digital assets? Digital assets include anything stored electronically, such as email accounts, social media profiles, online banking, digital currencies, and more. These assets fall into several categories: personal, financial, social media, and business-related. To begin, identify your digital assets. Create an inventory listing all your digital assets along with usernames, passwords, and security questions. This inventory will be essential for your executor or beneficiaries to access and manage these assets after you're gone. Legal considerations are also important. The legal framework surrounding digital assets can be complex. Laws such as the Revised Uniform Fiduciary Access to Digital Assets Act, RUFADAA, help govern how digital assets are handled after death. Understanding these laws will help you create a more effective digital estate plan. Access and control are crucial elements. Ensure your executor or beneficiaries can access your digital assets. Use password managers and secure storage solutions to store your login information. This makes it easier for your trusted individuals to access your accounts when needed. Include specific instructions for handling your digital assets in your estate plan. For social media accounts, you may want to specify whether they should be memorialized or deleted. For email accounts, provide clear instructions on how to manage or close them. For online banking and digital currencies, outline how these assets should be transferred or accessed. Appointing a digital executor is another key step. A digital executor is responsible for managing your digital assets according to your wishes. Choose someone tech-savvy and trustworthy. Clearly outline their responsibilities and the extent of their authority in your estate plan. Regularly update your digital estate plan. Review and update your digital asset inventory to reflect new accounts, changes in passwords, and other updates. This ensures your plan remains current and effective. Protecting privacy and security is paramount. Take steps to protect your digital assets against identity theft and data breaches. Use strong, unique passwords, enable two-factor authentication, and store your inventory in a secure location. Communication is essential. Inform your executor and beneficiaries about your digital estate plan. Provide them with access instructions and necessary documentation to ensure they can manage your digital assets effectively. Let's look at a real-life example. Imagine someone who has significant online assets, including a blog generating income, multiple social media accounts, and digital currencies. By creating a digital estate plan, they ensure their digital executor can access these assets, manage them according to their wishes, and distribute any financial benefits to their beneficiaries. In summary, digital estate planning involves identifying your digital assets, providing access and control, including specific instructions in your estate plan, appointing a digital executor, regularly updating your plan, and protecting privacy and security. By including digital assets in your estate plan, you can ensure a smooth transition and protect your digital legacy.
In this video, we will explore the benefits and process of buying property through a trust. A trust is a legal arrangement where one party, known as the trustee, holds property for the benefit of another party, known as the beneficiary. Trusts can be used for various purposes, including estate planning, asset protection, and privacy. One of the main benefits of buying property through a trust is asset protection. Properties held in a trust can be shielded from creditors' claims and lawsuits. Additionally, trusts offer privacy by keeping ownership details out of public records. When it comes to estate planning, trusts allow for the efficient transfer of assets upon the owner's death, avoiding the lengthy and costly probate process. Trusts also provide control over how and when assets are distributed to beneficiaries. Properly structured trusts can offer significant tax benefits, reducing estate taxes and providing other tax advantages. Several types of trusts can be used for buying property. A revocable trust allows the grantor to retain control and make changes to the trust. This type of trust is ideal for estate planning and can simplify the transfer of property after death. An irrevocable trust, once established, cannot be altered or revoked. This type of trust provides stronger asset protection and potential tax benefits. Charitable trusts allow property owners to support charitable causes while receiving tax benefits. Special needs trusts are designed to provide for beneficiaries with special needs without affecting their eligibility for government benefits. Now, let's go through the steps to buy property through a trust. First, establish the trust with the help of an experienced attorney. This involves drafting the trust document and naming the trustee and beneficiaries. Next, find a suitable property that aligns with your investment goals and the terms of the trust. If financing is needed, work with lenders who are familiar with lending to trusts. Ensure the property is titled in the name of the trust, not the individual, to maintain the legal protections and benefits of the trust structure. Once the property is purchased, the trustee will manage it according to the trust terms, ensuring that all obligations, such as taxes and maintenance, are met. Trustee duties include managing trust assets, maintaining the property, keeping up with property taxes and insurance, and acting in the best interests of the beneficiaries. Trustees must also keep detailed records and provide regular reports to the beneficiaries. Beneficiaries have the right to access trust documents, receive regular updates, and receive distributions as specified in the trust document. They must comply with the terms and conditions outlined in the trust and stay informed about the trust's activities. Key considerations for buying property through a trust include understanding the legal and tax implications. Trust laws can vary by state, so it's important to ensure compliance with local regulations. Engage an experienced attorney to navigate the complexities of setting up and managing a trust. Practical steps for trust management include regular property inspections, creating a budget for property expenses, and developing a prudent investment strategy for any income generated by the property. In summary, buying property through a trust offers significant benefits, including asset protection, privacy, estate planning advantages, and tax benefits. However, it requires careful planning and management.
The role of life insurance in succession planning. Welcome back to our series on estate planning for business owners. In our previous videos, we've explored various aspects of business succession planning. Today, we're going to focus on the role of life insurance in succession planning and how it can be a valuable tool in ensuring the smooth transition of your business. Life insurance can play a critical role in business succession planning by providing the necessary funds to address financial needs that arise upon the death of a business owner. Let's look at some specific ways life insurance can be used in your succession plan. First, let's talk about buy-sell agreements. A buy-sell agreement is a legally binding contract that outlines how a partner's share of the business will be handled if they pass away, become disabled, or decide to leave the business. Life insurance can be used to fund these agreements. For example, if you and your business partners each take out a life insurance policy on each other, the proceeds from the policy can be used to buy out the deceased partner's share of the business. This ensures that the business remains in the hands of the surviving owners and provides financial support to the deceased partner's family. Second, life insurance can provide liquidity to pay estate taxes. For many business owners, a significant portion of their wealth is tied up in the business. When they pass away, their heirs may face substantial estate taxes. If there aren't enough liquid assets to cover these taxes, the business might have to be sold or liquidated to pay the tax bill. Life insurance proceeds can provide the necessary funds to pay estate taxes, allowing the business to continue operating without disruption. Third, life insurance can be used to equalize inheritances. If you have multiple heirs, but not all of them are involved in the business, life insurance can help ensure that each heir receives a fair share of your estate. For example, you can leave the business to the heirs who are involved in its operations and use life insurance proceeds to provide an equivalent value to the heirs who are not involved. This can help prevent conflicts and ensure that all your heirs are treated fairly. Another important use of life insurance is in key person insurance. Key person insurance is a policy taken out by a business on the life of an essential employee, such as an owner or top executive. The business is the beneficiary of the policy, and the proceeds can be used to cover the financial loss that occurs when a key person dies. This can include costs related to finding and training a replacement, lost revenue, and reassuring creditors and customers that the business will continue to operate smoothly. When considering life insurance for succession planning, there are several types of policies to choose from. Term life insurance provides coverage for a specific period, making it a cost-effective option for temporary needs. Whole life insurance, on the other hand, provides permanent coverage and builds cash value over time, which can be used for other financial needs. Universal life insurance offers flexibility in premium payments and death benefits, allowing you to adjust the policy as your needs change. It's essential to work with a qualified insurance advisor and estate planning attorney to determine the best type and amount of life insurance for your situation. They can help you understand the options available and ensure that the policies align with your overall succession plan. In summary, life insurance is a versatile and valuable tool in business succession planning. It can provide the funds needed to buy out a deceased partner's share, pay estate taxes, equalize inheritances, and cover the financial loss of a key person. By incorporating life insurance into your succession plan, you can ensure the continuity and stability of.
Can you sell a house that is in trust? If you own property and are thinking about establishing a trust to safeguard your assets, many people ask, can you sell a house that is in a trust? The answer is generally yes, although the process can be intricate, requiring a thorough understanding of the various steps involved. In this guide, We'll walk you through the basics of selling a house that is in trust, including what a trust is, how it affects the sale of your property, and what steps you need to take to sell your home successfully. We'll also offer some tips on how to ensure your sale goes smoothly and efficiently, so you can get the best possible outcome for your situation. What is a trust? First, let's define what a trust is. A trust is a legal arrangement that allows you to transfer ownership of your assets to a trustee, who will manage those assets on behalf of the beneficiaries you name in the trust. The trustee has a legal duty to manage the assets in the trust in accordance with your wishes, as outlined in the trust document. There are different types of trusts, but the most common is the revocable living trust. With this type of trust, you can transfer ownership of your assets to the trust during your lifetime and retain control over them as the trustee. You can also name yourself as the beneficiary, so you can continue to use and enjoy your assets as you did before they were placed in the trust. The trust becomes irrevocable after your death, at which point the assets are managed by the successor trustee you named in the trust document. An important question to ask is, how does a trust affect the sale of a house? If you've transferred ownership of your house to a trust, the trust now owns the property, not you personally. This means that you can't sell the house yourself. The trustee must handle the sale on behalf of the trust. However, as the grantor, creator of the trust, you can give the trustee the power to sell the property by including specific provisions in the trust document. For example, you can include language that allows the trustee to sell the property at any time or only under certain conditions, such as when the beneficiaries agree to the sale. It's important to note that the trustee has a legal duty to act in the best interests of the beneficiaries when managing the assets in the trust. This includes the sale of the house. The trustee must make decisions that are in the best interests of the beneficiaries, such as selling the property for the highest possible price or using the proceeds of the sale to benefit the beneficiaries in another way. Here are the steps to selling a house that is in trust. Now that you understand the basics of how a trust affects the sale of a house, let's walk through the steps involved in selling a house that is in trust. Step 1. Determine the trustee's powers. The first step is to review the trust document to determine the trustee's powers regarding the sale of the property. If the trust document grants the trustee the power to sell the property, the trustee can begin the process of listing the property for sale. Step 2. Choose a real estate agent. The trustee should choose a reputable real estate agent who has experience selling properties that are in trust. The agent should have a deep understanding of the legal and financial aspects of selling a trust property, as well as the ability to work collaboratively with the trustee and beneficiaries. Step 3. Prepare the property for sale. Before listing the property, the trustee should prepare it for sale. This may involve making necessary repairs and improvements, staging the property, and setting a fair market price based on comparable properties in the area. Step 4. List the property for sale. Once the property is prepared, the trustee can list it for sale with the chosen real estate agent. The listing should include all necessary information about the property, including any disclosures required by law. Step 5. Accept an offer and negotiate. When a potential buyer makes an offer on the property, the trustee should review it and consult with the beneficiaries before accepting or rejecting it. If the offer is accepted, the trustee should negotiate the terms of the sale, including the price, closing date, and any contingencies. Step 6. Transfer ownership of the property. Once the terms of the sale have been agreed upon, the trustee should work with the real estate agent and the buyer's attorney to transfer ownership of the property. This may involve completing necessary paperwork and providing documentation related to the trust and the sale of the property. Step 7. Distribute proceeds to beneficiaries. After the sale is complete and any outstanding debts and expenses related to the property have been paid, The trustee should distribute the proceeds from the sale to the beneficiaries in accordance with the terms of the trust. Selling a house that is in trust can be a complex process, but by following these steps and working with experienced professionals, it can be a smooth and successful transaction. Thank you for tuning in, and if you have any further questions or need legal advice, feel free to reach out to us at Heritage Law Office.
Is a Medicaid asset protection trust worth it? Let's do the math. A typical nursing home stay costs $9,000 to $11,000 per month. That's over $100,000 a year. 70% of people over 65 will need nursing home care at some point. 1 in 5 will need care for more than 5 years. We help clients set up a Medicaid asset protection trust for $8,500. A one-time cost that can protect your home or savings from being spent down in long-term care. If Medicaid covers your nursing home bill even 1 month earlier than it would have without the trust, you've already recovered the cost. Stay 6 months in a facility? You could save over $50,000 in protected assets. Stay 12 months? That number doubles. It's not just about the money. It's about peace of mind, preserving your legacy, and having options.
In this video, we will discuss how to manage inherited property during probate, covering essential steps and common challenges you may face. Welcome to our channel. If you're dealing with the complexities of probate and inherited property, this video is for you. Let's dive into the key aspects of managing inherited property during probate. First, let's understand the probate process. Probate is the legal procedure of administering a deceased person's estate, ensuring debts are paid, and distributing the remaining assets to the rightful heirs. When handling inherited property, you'll need to locate and review the will, inventory the estate, notify creditors, settle debts, maintain the property, and decide on its future. One of the common challenges in handling inherited property is emotional attachment. Family disagreements can arise when heirs have differing opinions on what to do with the property. Sentimental value can also complicate decisions about selling or renting the property. Additionally, financial considerations like the costs of maintaining the property and potential tax implications need to be addressed. Legal complications, such as dealing with multiple heirs or unresolved debts, can also present challenges. If you decide to sell the inherited property, there are several steps to follow. First, prepare the property for sale by making necessary repairs and upgrades, and ensure it is clean and staged. Hiring a real estate agent experienced in estate sales is crucial. They can help you list the property, conduct a market analysis, and market it effectively to attract buyers. Finally, navigate the sale process by evaluating offers, negotiating terms, and finalizing the sale with the help of your agent and attorney. Here are some practical tips for handling inherited property efficiently. Stay organized by keeping meticulous records of all transactions and communications. Use digital tools and software to track important documents and deadlines. Seek professional advice from estate attorneys and financial advisors to navigate legal complexities and plan for tax implications. Communicate effectively with family members through regular meetings and open discussions. Lastly, be patient and compassionate, recognizing the emotional impact of losing a loved one and providing support to each other. In summary, managing inherited property during probate involves understanding the probate process, addressing common challenges, and following practical tips to navigate the complexities. If you need assistance, our knowledgeable attorneys are here to support you every step of the way. Contact us to ensure the probate process is as smooth.
Thinking about how to protect your assets and make life easier for your loved ones? A revocable trust might be the answer. A revocable trust lets you transfer ownership of your assets, like your home and bank accounts, into a trust while keeping full control. You can buy, sell, or move assets in and out of the trust just like always. And since it's revocable, you can change or cancel it anytime you want. One major benefit? Avoiding